So, what are the remedies? What are the remedies for wrongful termination and wrongful dismissal? Where an employee goes to court to say, oh, my employment has been terminated wrongfully, due process was not followed, what are the potential remedies that the court will grant? In private employment, the court will not impose a willing employee on an unwilling employer. So, where an employee challenges wrongful termination or wrongful dismissal and it succeeds, the remedy that the court will grant is award of damages. The court will not make an order of reinstatement. The reason being that the court will not impose a willing employee on an unwilling employer. But where the employment has statutory flavor, that is employment in public service, where your employment is governed by law, not by contract, where the employment is governed by a statute, like, for instance, people employed in public service in CBN, NNPC, public universities, CTC, because the mode of their appointment and determination is governed by a statute or a statutory regulation, the employment is said to have a statutory flavor, and where their termination or dismissal is successfully challenged, the remedy that the court will give them will be reinstatement. That is another directing them to go back to their employment with all accrued salaries and benefits. But in private employment, in private sector, the remedy that will be readily granted is award of damages. Distinguished ladies and gentlemen, this is the end of my 45 minutes presentation. Thank you.
Wow, Bimbo, you've done justice within 45 minutes and you kept your time. Awesome. Thank you so much. Thank you very much for it. We'll be attending to questions. There's a lot of questions that came in before, while some people registered, and we're going to attend to those ones. And other questions are already on the chat room. We're still going to spend time to attend to that. So I'll be taking my session just for within a few minutes, and then we can delve into the question session. Thank you. I want us to understand one fact, that the issue that surrounds employee leaving an organization comes with a lot of emotions, because as human beings, we are moving emotions. And as moving emotions, we are prone to triggers. And these triggers are often initiated by the words we use and the actions that we take. So in employment relationship, it is important for us to manage the emotions that comes during this process. The next slide. Termination, resignation, suspension, dismissal, they are part of employment cycle. So you need to understand that during this employment cycle, one will definitely happen. However, resignation sits with the employee majorly. I know our legal expert has advised that you should not advise people to resign. But there are situations whereby it may be cordial between the two parties, and the person says he understands the fundamentals and he wants to leave. Based on that, the person needs to put it in writing, and so that the process can go seamlessly. However, forcing people to resign, coercing them to resign, should be disregarded, should not be part of the practice as professionals. The next slide. There are 2 C's in the employment cycle. From the point of onboarding to the point of exit of an employment, of an employee life cycle, there are 2 C's I have discovered. The two C's that speaks to conduct and capacity. And conduct speaks to behavior, character, the attitude that has been exhibited during the employment process or the employment life cycle. And capability speaks to the area of performance. How good is the employee doing as regards meeting up to the minimum expectation of the employer? The set goals and the expectations clearly stated. So these two C's needs to be taken seriously as professionals. Next slide. I want to give us 3 allied steps, proactive steps we should take during the employment cycle. Number 1 is the way you start an engagement is very important as professionals. The onboarding sessions. The big question is, how do we handle employees onboarding? Oftentimes we joke with it, we don't do it properly. The onboarding session is a session that needs to be well detailed and documented. It's a session where you need to effectively communicate the policies, the processes, the expectations, the reward, the future that surrounds the progress of that employee. Communicating the disciplinary grid is key during the onboarding session. You need to know at different level the minimum expectation, the conduct that are not permissible, that are not admitted in this organization. Number 2 is your termination and your dismissal process should be supported with data and documentation. I will employ us to understand that whatever you cannot measure, whatever you cannot document, you cannot manage. I say it again, whatever you cannot measure as data, whatever you cannot document qualitatively, data quantitatively, you can manage it. I want to see us as professionals whereby we put some data when issues of misconduct, even if it's a minor misconduct, put a data to it. If it is a serious misconduct, put data to it. And let the employee begin to see their scorecard and you document it appropriately. Because a day will come, you will need this information. A day will come, your organization will be depending on you that you ought to have known better to advise us or to ensure the process becomes seamless. I will also leave one simple equation with you, because termination and dismissal is an event. And in that event, your reaction or your response will determine the outcome of that event. Will outcome become smooth? Will the outcome become a crisis situation that the organization will now blame you as a professional? It's in your hand. The simple equation is E plus R is equals to O. O, yes. Where E represents event, the R represents response or reaction, and the O determines the outcome. Are you reacting to the situation or are you responding to the situation? The issue surrounding termination oftentimes doesn't just come up immediately. There are events that have surrounded it. How good are you while documenting these events? The third one is record the various interventions to improve the employee performance and conduct. In the course of managing low performance, in the course of managing bad behavior, I know as HR professionals, you would have come up with intervention programs, either through mentoring, hand-holding, coaching, one-on-one counseling. I advise us to always document it and check the improvement. These are proactive steps to guide you in case when we get to the point of no return. The next slide. Reasons for letting go. Low performance issue is one of the reasons. Poor professional conduct is also it. Legal issues that speaks to area of theft, harassment, releasing classified information to third parties, becoming a competitor overnight to your employer. These are legal issues which need to be well documented. No showing in the sense you are not appearing in the office as at when due. Not the right fit. Not the right fit comes from the area of competency. As the job, you have already branded your resume. You have told the employer everything that you can do. On the premise of that, you are so convincing during interview and you have been employed. And when the real deal comes, you cannot perform. After different intervention, and you cannot still perform. So you are not a right fit for that job. Employee can come across as an asset or a liability. Not enough work, which is redundancy, as stated by our guest, could happen, and you have to let employee go. So the best practice for firing and terminating from the human face is this. It is important to fire someone with kindness. Put yourself in the employee's shoes and imagine how significant that will change their life if they don't have a job. So it is important to keep the conversation respectful and provide evidence as to why you made the decision you made. We have read on different platforms, different articles, we've watched videos, how people have committed suicide because they have been terminated. We don't want to be seen orchestrating or initiating that move. So it is very sensitive. We have seen situations whereby the processes were not well handled and the employee goes ballistic and inflict injury on some HR professionals. We don't want to see those happen. The next slide. The next slide. Best practice for terminating. Remember, you can risk your company's reputation if you don't handle it properly. And with fast finger generation we have, with strong awareness as regards their fundamental rights, people go to as far as Glassdoor, international platform, to put comments up, to send reviews about your organization. And that will negatively affect your employer's brand. Your organizational brand will become questionable. The next slide. So you can fire someone nicely using this best practice. As a professional, give yourself time. What does that mean? Give yourself time to process your action and be confident enough and you are ready for it. Number two, practice the conversation. Know what to say, select your words, do an internal conversation within yourself. While you are doing it, please bring a witness to the process. It's important to have witness to the process. Don't do it alone. Be clear about the subject. Don't digress. Because in the court of law, it is the subject matter that is before the court that will be attended to. Don't digress. Don't bring sentiments. Don't be tribal in your communication. Be very clear with simple words. And be firm. Be very firm with your decision. Avoid emotional response. And what does that mean? The person can tell you at that point, I promise you, I am going to be better. I am going to be this. I am going to be that. Don't be seen to be an HRO practitioner that can easily shift and allow a peaceful goodbye. If the employee wants to say goodbye to his colleagues, if you sense it is good, you can allow the process. If you have to have an handshake because the way you have communicated it is peaceful, then you allow an handshake. Because the beginning of a thing is always sweet when it comes to engagement. Oftentimes when we need to pull the plug and we go our separate ways, it's not always a palatable experience. Lastly, reflect on the termination. After it, reflect on it. And lastly, in addition, communicate to the rest of the team. Because employees will definitely go out and tell their own version of the story, and you will not be there. So proper communication, the reason why A has left is important, except if it is based on some classified sensitive reasons that you know is not good for the person's character or the person's personality. But it is good to communicate. Don't leave the team without communication, because they will hear the other side of the story and you don't have your own opportunity to share. Thank you very much. I spent less than 20 minutes in my own session. Thank you very much. Wow, it has been a great time. Hello, Mr. Bimbo. Bimbo, are you still on this call?
Yes, I'm here.
Fantastic.
I'm here.
So we are done with the sessions. We have a lot of questions, but we're going to give opportunity for those that sent in their questions before now. And a lot of questions are already on the chat room. And we trust we'll be able to wrap it up within the stipulated time. It's an holiday. We appreciate everyone for coming. Thank you so much for the comments, quite insightful.
So,
We appreciate it.
So, TJ, can you please assist to read out the questions while I take them one after the other?
Yes, we will deal with it. Number one question is this: what are the legal implications if an employer cancels the employment contract before a newly hired employee resumes?
So, you are issued a contract of employment, which you have accepted. Before you resume, the employer now sends you a letter of termination. First and foremost, it can be considered as an unfair labor practice when we take note of the fact that such employees are coming from another employment, and based on the fact of their own acceptance of your offer, they have tendered letter of resignation elsewhere. And this happened a lot during COVID. In fact, we did a lot of matters around that during COVID, where people admin issued contract of employment in January, February, early March of 2020 to resume the following month or 2 months after. And based on their own acceptance of your offer, they have dropped their letter of resignation with their current employer, only to receive another letter before resumption that the employment is terminated. So that in normal period like this time, that can be tagged as an unfair labor practice because you offered a job which either did not exist or you are not or which responsibility you are not prepared for. So that can be challenged and damages will be awarded. During COVID-19 crisis, a lot of people who had offers of employment were asked not to resume. Some had the contract terminated before they could resume. And some of these cases went to court. And what the court awarded, in the few cases that I'm aware of, what the court awarded was, one, the payment in lieu of notice and nominal damages, because COVID-19 was a peculiar circumstance, which was a global challenge that the court itself took judicial notice of. But in normal times like this, you issue a contract of employment, I accepted it, you gave a resumption date on the basis of which I tender my own letter of resignation. A week before resumption, you now terminate it. Of course, I will land you in court and I will seek damages because you have destroyed the career. So,
okay, thank you, Mr. Bimbo.
So it is a potential breach of contract and an unfair labor practice. Next question, please.
Okay, no. On the flip side now, Mr. Bimbo, a lot of employers, they've suffered a situation whereby he has accepted the offer. 2 days to resumption, he declined. What do we do as employer?
Well, like I said earlier, when employees resign, you hardly see employer going after them.
No, this is not even a resignation now. I will not want to call it a resignation.
It is a resignation because they have accepted
you have to look
resume.
at the offer. Now, they decided to just leave without notice.
Now,
because they're supposed to resume on Monday. They're supposed to resume on Monday. Yes. On Friday, they sent an email. I am sorry, blah, 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 blah.
It is still a resignation.
Without notice?
As in they are signing out. They are signing out from a contract. It's still a resignation. But what employer should do in such circumstance to send right lessons is that they should thank him for his interest in the company, and we have equally noted your decision not to resume. So, however, you need to pay us 1 month in lieu of notice or whatever is in the contract, because you have accepted the contract. A contract is consummated. So, if you are coming out of it, you must also resign in accordance with the contract which we have executed. But in practice, employers do move. They don't. You see, they want to fill a space. They are not. They are not keen to. And let me tell you what most employees do. They use that contract to go and negotiate with their current employer. Say, Oga, they go. Can you pay 12 million per annum? You are paying 7 currently. See my offer. So most time they use it to negotiate. And when they use it to negotiate, the current employer now matches up with the current offer. So they will just send an email across. But yes, and let me quickly say this, the right to resign from an employment is a fundamental and absolute right. Absolutely. Which nobody can hold. So an employee has a right to resign, to leave employment at any time, but subject to notice or payment in lieu of notice. So what employers should begin to do to make them accountable for such otherwise irresponsible conduct is to say thank you for your interest, We have also noted your resignation. Please, can we have your payment in lieu of notice?
Yeah,
But
thank you for the comment.
But like a commentator just said, employers don't have that time. They would rather direct that energy to get the space, the vacancy filled, than pursuing you for 1 month notice or 2 month notice in lieu of 1 month salary or 2 month salary in lieu of notice, which most times is usually computed on basic pay basis.
Absolutely, absolutely. Number 2 question. We have close to about 50 questions to answer today. How enforceable is the non-compete agreement on an employee whose contract was terminated? To what extent are non-compete agreements generally enforceable?
So let me quickly say this. Non-compete agreement, otherwise called covenant in restraint of trade and employment in labor and employment law, as a general rule, is unenforceable, illegal, null and void because they are contrary to public policy, as a general rule. And there are English cases on this. There are also Nigerian cases on this. You can see the English case of Northern Veld and Northern Veld. And we have several Nigerian cases, the La Casera cases of this world, etc., etc. So as a general rule, it is null and void. But there's only one exception where the court will enforce non-compete clause, where the employer can show that the employee has his trade secret. That is, where the employer can demonstrate with evidence that the role that the employee occupies in his employment is one that offers him access to trade secret. For instance, if you are a production manager in a beverage producing company, the employer can say in the contract that when you leave me, you cannot join a competitor or another beverage producing company, and you cannot establish one for 1 year anywhere in Lagos State, for instance. The only way you can enforce it, where the court will enforce it, is where you can show that the employee's role in your company offers him access to your trade secret. And for a production manager, you can easily explain that, look, the composition, the mixture composition of my drinks is a trade secret, and that if he leaves me to go and establish his own or join a competitor, he's going to take my recipe or my composition, my production formula to another company. In that case, the court can stop him and enforce the non-compete contract. For instance, you are a chef in a restaurant in an amala joint in Lagos Island, and you want to, I can have a non-compete clause in your contract that when you leave me, you can establish another amala joint or join one within Lagos Island. And the court will enforce that because you may be able to demonstrate that you have a recipe that makes people to come from mainland to VI to come and eat your amala. That makes people to come from Ipaja to VI to come and eat your amala. The court will enforce that. The second condition, the geography must be reasonable. The restraint must be limited to the area where you do your business. So if your amala joint is in VI and you want to restrain me by way of non-compete, you can't say that I can't establish amala joint or join a competitor within Nigeria. The court will strike that down because your business is in VI, not in the entire Nigeria. So why can't I join or establish amala joint in Ibadan, in Abuja, in Kano? So as a general rule, it's null and void, except you can show certain conditions. One, that the employee occupies a position that offers him access to your trade secret. And I'll give you an example of what constitutes trade secret. And two, the geography of restriction must be limited to where you have your business. And three, the duration must be reasonable.
Thank you so much. We need to be fast with the response, Bill. In which circumstance is it permissible for an employee be penalized through salary deduction? Is salary deduction one of the punitive measures when you want to deal with misconduct issues?
Well, let me say this. Salary deduction as a sanction is not a best practice. To be honest, it's not a best practice. Employees can otherwise be dealt with by other sanctions on your sanction grid, such as final warning, written warning, suspension without pay for a few days. But deduction of salaries is not a best practice in disciplinary matters. Next question.
Is that your question? Okay.
Next question.
In which, if it has chances, if it has been documented punitive measure, if you do this, you come late, X amount will be taken away, and it was documented during your employment and you sign.
It is not a best. I'm not saying it is illegal or unlawful. It is not a best practice. It's not a best practice. So somebody asked a question. What about cases of surcharge for a willful destruction of the company's property? So Nigerian Labour Act has provision for surcharge for willful destruction of company's property, but that's a procedure. The employee must have been afforded fair hearing. And let me shock you. Labour Act says that process must be endorsed by an authorized labor officer.
From the Ministry of Justice?
Yes, from Ministry of Labor.
Okay.
Yes. Labour Act recognizes that there can be a surcharge for destruction of property, of company's property. But there must be a fair hearing for that. And that process must be endorsed by an authorized labor officer. So do you want to go to Ministry of Labor? But we know that in practice, employers do all sorts. Next question.
Okay, we also will be balancing it because people have been asking questions on the chat and we have been responding. So we'll balance it. What can be done if an employee resigns with a notice period that is less than the required notice period? Because there's always an issue that I have a leave, I can use my leave as part of the process. That has always been the reason sometimes.
Most policies, most employment policies, and I don't make that mistake when we design or review employment handbook. Most policies usually state that employees cannot use their accumulated leave as a substitute or as a replacement for notice period in the event of resignation. So it's either you give your notice and serve it out, or you make payment in lieu of notice. And where an employee gives insufficient notice, you can ask that they make payment in lieu of notice for the remaining period, and you can enforce it in a court of law. But again, employers hardly do this.
When a staff submits a resignation, can a staff submit a resignation when it's under serious investigation?
No. Yeah.
So, National Industrial Court has heard in several cases that employee can tender their resignation at any time of their choice, including during investigation and disciplinary process. And you can see the case of Ine Ngbeti versus Unity Bank. You can Google it, Ine Ngbeti versus Unity Bank, where a clause in the employee handbook that says that you cannot resign while investigation or disciplinary process is going on. The court held that that clause is null and void and is contrary to the right of an employee to leave employment at any time of his choice. In fact, in the Court of Appeal decision, Tagunoromo's case, the court held that such practice to say an employee cannot resign during investigation or disciplinary process, that such practice amount to forced labor, contrary to Section 34(1) of the Constitution and contrary to the Labor Act that prohibits forced labor. So, employee can resign at any time of their choice by giving notice or making payment in lieu of notice.
Thanks, sir. Somebody raised up his hand, one Sheyi. Do you have a question or a contribution?
Yes, Barrister, good afternoon, sir. How are you, sir? My name is Sheyi.
Very well, sir.
Yeah, I've also discovered that the labor law has provision for leave. For notice of resignation. However, a lot of companies have this copy and paste practice. So while I was doing my handbook review, a lot of people don't also know you need to send to Ministry of Labor for attestation. So Ministry of Labor returned the handbook to say we must follow the provisions of the law for notice of resignation. So we discovered that the law has a different provision from what we've been carrying on as practice over the years. So I needed to just bring that to, because I know you've also mentioned that
Now, let me quickly
during
say
one of
this.
our meetings.
Let me quickly say this. The law you talk about is in the Labor Act. When you look at the Labor Act on notice period, you will see 1 week, 2 weeks, 3 weeks. Those provisions are default provisions where there is no provisions in your employee handbook or contract of employment. So they will only take effect where the contract of employment is silent on it on notice period, or where the employee handbook is silent on notice. Nobody goes to Labor Act to determine the notice period that you are going to give to your employee to terminate, or notice period that the employee will give to employer to terminate, or payment in lieu. Nobody goes to Labor Act. You will only need to go to Labor Act in the unlikely event that the contract of employment is silent on notice period, and 2, where the employee handbook is silent on notice period. And there is no law that says you must send your employee handbook to Ministry of Labor for attestation. No. What happens is that when they come for audit, they will ask for a copy of your employee handbook. And when they go through it, if they see some provisions that are not right, they can ask you to correct it. So there is no law that says when you design your employee handbook or you review it, that you must send it to Ministry of Labor. No. But when they do their audit, when they send letter to company from time to time, want to come and check your company, are you complying with safety laws, with Labor Act? One of the documents they ask for is your employee handbook, and they may tell you that this provision, go and include it or go and work on it. And like I said, nobody goes to Labor Act to determine notice period. It's usually provided in the contract of employment. So
but it has been challenged by the union before. That's why that came up. The union challenged notice period as provided in the handbook against the labor law.
If you look at the Labor Act, the notice period you will see are even ridiculous. You will see 1 day, 7 days, 1 week, 2 weeks. There is no employer.
Exactly.
The minimum that you will see in contract of employment today, average, is usually 1 month. So what I'm saying is that the unions may not be aware. What I'm saying is that the notice period in the Labor Act is a default provision. And let me shock you, Labor Act governs employment of junior workers only. Labor Act does not apply to anybody who is in managerial, who is exercising professional or administrative work. Nobody in this platform, as I'm talking this evening, can claim provisions under the Labor Act. You are all governed by your contract of employment. Labor Act is for junior workers. And that's why when you look at the provision, you see some ridiculous provisions there.
Yeah,
So the
we're
notice
pressed
period,
for time.
the notice
So what's
period
the
in Labor
balance
Act
in
is
this?
a default provision.
Yeah, we still have another opportunity for all these questions. We still have a lot of opportunity that will communicate, after this. There is someone there, Rotimi Arowolo. Let us take your question. We still have many questions we've not even touched. We are not even 20%
Wow.
questions. Yes.
Thank you so much, sir, for the opportunity to ask. Vice BC, thank you so much. It's awesome having to listen to you. So quickly to my question, it is as regards the right of the employee to submit resignation, whether under investigation or not. Now, my question is, if an employee is under investigation and there are some level of certainty as to the misconduct, and the employee submits resignation, and because it is the right, he exits, what becomes the lot of the company? What does the company do?
I've told you now, several decisions of NIC say that an employee can resign at any time in the course of employment, including 1 day before appearance before disciplinary panel. What he owes you is payment in lieu or notice period. However, if what the employee did, if it is also a crime, for instance, if it involves fraud, stealing of money or forgery, you can go and lay your petition before police, EFCC. That one can take place at any time, whether or not it's in your employment. But your disciplinary powers over an employee ceases when resignation takes effect. And they are very smart these days. What they do is resignation with immediate effect.
Hmm.
Thank you, sir.
Okay, let us take questions again. How do you handle an exit instruction that is contrary to the policy of the organization and directed at victimizing someone based on selfish interests? All advice against it fell on deaf ears.
So you document your advice. Let it be on record that you advise against it.
Absolutely, absolutely.
Thank you.
Absolutely.
Next question.
The next question, please, the slide. So we go back to the question. There's a lot of questions in the chat room currently. Now the question, how do I handle an employee? Bimbo, are you still with me?
Yes, I'm here.
Fantastic. How do I handle an employee who was given a query for her lateness to work and she refused to acknowledge the copy of the query, let alone answer the query, and upon her refusal to do so, she just left the office in annoyance? Bimbo, advise us.
Well, and after leaving the office, she didn't come again.
Mm.
Every standard employee handbook has what we call job abandonment. So it doesn't come the following day and the very next day. So you just send her a letter of termination of employment. And if you want to dismiss, you send her an invitation, either a query to her email. And if she doesn't reply, you can proceed to take a decision. So that is job abandonment. I mean, it's nothing to worry about.
Okay, fantastic. Is it legal that the above employees has forfeited a salary for the month and also accrued benefits? Is it legal for you to, put a hold on the person's salary and accrued benefits?
If the consequence is dismissal,
yes,
after issuance of query, then in dismissal, an employee loses accrued benefit, but not accrued salary. In dismissal, an employee, what an employee loses is terminal benefits, if any, not salary.
Okay.
Terminal benefits, including bonuses, all those ones are hand. So an employee whether it's dismissal or termination, all earned benefits will be paid. The only thing that the employee loses is payment in lieu and terminal benefits, such as gratuity, if you still have one in your policy.
Okay. Can a company initiate a legal action against an employee under the labor law for not handing over properly the company's possession with her as at the time she left the company?
Does it really worth your time and effort? Nobody does that. If an employee resigns without proper handover, you can only place a call to let him or her know that there are other few things he or she needs to do. But if it borders on company's property, like official car or laptop, of course, you can involve the police because that will amount to criminal conversion. If it involves company's property like official car or laptop, you can involve the police. But an employee has resigned without proper handover, you can only persuade, please, is it not better you do this? Next question. Next question. TJ, are you there? I think he's angry from inside. Hello, TJ.
Back here. Okay, the next question, should an organization engage the service of a security man to help recover a stolen fund from an employee? Or what should be the best practice?
Where there are cases of fraud or stealing, which is a criminal allegation, you have the right to involve the security agencies who can invite him or her, who can arrest, who can prosecute. Next question.
Okay. What are some best practices for ensuring that the termination process is both legally compliant and respectful to the employee, particularly in sensitive situations? We don't know what
that is what we have discussed today.
Yes. Yes.
Next question.
How can employers communicate the reason for termination to an employee in a way that minimizes potential legal risks while also preserving their dignity and well-being? I believe I also shared in that regard.
That's what myself and TJ have discussed.
Awesome. Sheyi is still asking a very sensitive question. He says, does it mean staff can exit as they like with all these provisions, with all these precedents from different rulings between employers and employee? Does it give a room for people to just resign like that? Bimbo. Bimbo, I don't know if you heard me.
Please repeat.
Yeah, that's a question from Sheyi. He say, meaning resign staff can exit as they like.
Absolutely. By giving notice or making payment in lieu of notice.
Someone is saying NIC is pro-employee. Do you agree, Bimbo?
It's not true.
Okay,
you see, what HR always fail to appreciate. You have invited somebody to face your disciplinary panel, and the person knows that the outcome will be termination or dismissal. And the person said, don't worry, and they go. So what is your problem? That's what HR doesn't appreciate.
And this is a great opportunity for you to attend this
Attend
training.
to other things.
Because
the man said, don't worry, I know the consequence. I'm going, don't worry. So
it is important, it is important to attend this training because there is always an assumption that when the matter becomes a legal issue, and if you have a very sound lawyer, ask for their legal opinion first before you carry out some of these actions out of what we feel this is how it's supposed to be. The courtroom is not like that. There are precedents, there are procedures, there are different laws, there are different interpretations. The way the laws are being interpreted is different from how the non-legal personnel, the trained ones, interpret it. So the training coming up in the month of May 8 and 9 is a great opportunity to dissolve your doubts, to help you out to structure your policy better, and to ensure that you minimize risks. It's important as HRO practitioners, professionals, we should minimize risks. We are risk manager before we expose our companies to classical issues. There is someone here, Lanre Lakunle Osene. Your hand is up. Your question, you have the floor.
Yeah, thank you very much. I actually put it in the chat, but I was asking that in the outsourcing relationship where you are a provider of outsourcing services to an organization and they ask you to take off some number of staff, because they'll say they are not my staff, so they return to you, say about 200 staff. How do you exit those people, effectively without it leading to litigation or any other issue?
So what you have just described is a very common problem. So you are an outsourcing company and you have an SLA with a client to supply manpower to them. And in the SLA, they have a right to increase the number, to reduce the number, or to terminate the SLA. And they have decided to terminate the SLA and they have returned your 200 staff to you. So that return to you, because you don't have another place to deploy them to, has triggered a redundancy situation in your own hand. So you will terminate them on account of redundancy, but redundancy comes with a cost. That is why we always advise clients that in your employee handbook, always have a redundancy provision that speaks to what you will pay in the events of redundancy, and that form part and parcel of your employment policy. For instance, a typical redundancy clause in employee handbook, we talk about 1 month salary for every year worked, or 1 month basic salary for every year worked. And we have also advised outsourcing companies, although clients hardly agree. We always advise outsourcing companies to insist that when you are returning staff to us, it's not only payment in lieu of notice that you should pay. You should also pay, for instance, another, especially if the return is not on account of poor performance and it's not disciplinary. You can negotiate a redundancy clause with them that if you are returning these people back to us, not on account of poor performance, but because you don't have a need for them, you should also pay, for instance, 1 month basic salary for every year worked with you. The reason being that you are going to declare redundancy for them because they are your employee, and they will challenge you for redundancy pay. But I equally know that most clients don't accede to that. So what you will need to do is to find a way on how to absorb the shock, because you need to, by asking them to go, what you have done as an associate company is to declare redundancy. That is, you have them in your hands, but there is no client to absorb them. So it is tough space, that I know, because most clients don't agree to have a redundancy clause included in the SLA. The only one they agreed to is that if we are returning clients, we pay you 1 month notice, 1 month salary in lieu of notice.
Yeah, in addition, we run outsourcing in our business. What we've done is you have a contract with the client. At the same time, you have a contract with the staff. And the terms and conditions are also stated in their own contract. And this contract, you can tie it in that area that you can terminate them with XY payment in lieu, because it can come at any point in time. But what we have done for some of our clients is that we've always put our foot down to ensure that when you are terminating, you should give us 2 to 3 months payment in lieu, not 1 year. And oftentimes that has passed through with most of the clients that we manage. You can take that one also as part of.
But Mr. TJ, let me quickly tell you,
Yes.
Payment in lieu of notice is not the same thing as redundancy pay. So if they challenge,
it depends on what you want to declare. I feel so.
It doesn't matter. If you are asking 200 people to go,
yes,
you don't need to tell anybody that is redundancy. If they go to court,
it's automatically redundancy.
If you go to look, you ask 200 people to go and you say it's not redundancy. So what it is? What is it? You have employees in your hand that you don't have a place to deploy them. So redundancy is a question of fact. It is not what you write in the letter. So if you terminate 1,000 people and you say service no longer required, or you say poor performance, or whatever you say, the fact that that's what you stated does not mean that is what has happened. If they challenge it in court, they will demonstrate it that, my lord, the reason why he asked us to go is because so bank has terminated his SLA, which in law is redundancy. But to avoid redundancy pay, he wants to treat it as regular termination. So it's not as easy as that. It is not what you call it that matter. It is what it is in law.
So, sorry, sir. Thank you for the clarity. Just one more, sir. Yeah. What if the contract is still in existence? Is there any way the litigation can affect the client as well? Because we don't want to lose our clients and want to manage this situation, sir.
So those outsourced employees are very smart now, and their lawyers are equally smart. So when they want to sue, they will sue you as the first defendant. They will make the client as a co-defendant. They will drag them because they know the party who will be more embarrassed. They also know the party who has more money to pay.
Absolutely. Yeah. Absolutely.
So once they join the client as a co-defendant, the client will now mount pressure on you that, look, we don't want this nonsense, so go and sort it out. So they know.
So the SLA needs to be right.
The SLA needs to be right. But like I said, in my experience, I know clients don't want to hear redundancy pay. What they want to sign on is payment in lieu of notice. So
awesome. There's a lot of liabilities with business.
This is a challenge to, but you see, it's equally good for the client company to understand this reality. Because when the employees are paid payment in lieu of notice without more, and they have sought legal advice, and they are told that what has happened in redundancy, that they are equally entitled to redundancy pay. After all, they have worked for 5, 6, 7, 8 years. When they are going to sue, they will sue you as a first defendant, make the client they work for as a co-defendant, which is also a reputational risk to them. So it is also in their own interest to understand this reality and also manage the potential legal risk.
Awesome.
But like I said, when
Okay.
it happens, the client company will now mount pressure on the outsourcing company. Please, this thing that your staff are doing, please go and sort it out. Otherwise, we won't give you business again. So in process of doing that, they put you under the box because you want to retain their services as your client. So.
Wow, it has been explosive. It's hot. It's very hot. Now, what is the legal redress that an HRO professional can take against the employer for declaring his HRO professional role redundant as a result of his professional stance on HRO issues, which he, the HRO professional, has enough evidence and proof that his retrenchment or his exit was done in bad faith by the employer?
If he can prove it, it's wrongful termination. If he can prove it, it is wrongful termination. Fantastic.
What are the essential steps to be taken before terminating an employee to ensure, okay, we've already touched that. Is suspension, is suspension without pay still applicable in today's HRO practice?
So in labor and employment law, there are two types of suspension. We have what is called disciplinary suspension, and we have what is called investigative or administrative suspension. Disciplinary suspension is a sanction, and as such, it is usually without pay. For instance, 2-day suspension without pay for late coming, 3-day suspension without pay for insubordination, 1-week suspension without pay for violation of the company's policy. That one is without pay because it is a sanction, it's a punishment for a misconduct after fair hearing has been given. The second category is investigative suspension. That is, where an employee is alleged of a misconduct and is placed on suspension to enable the company investigate the misconduct. That is investigative and ought to be with full pay because of presumption of innocence. The employee has not been found guilty. You just said you want to investigate. So to that extent, it has to be with pay.
Thank you. How do I fire an employee who is 50% in or is probationary period? There is already a clause in your offer letter concerning performance issue.
You only need to give reason for the termination.
You just need to give reason. Aside agreed entitlement, is an employee entitled to special damages for wrongful termination?
If the employee can prove
it
that the wrongful termination has occasioned him some damage or loss, the court will award special damages.
Okay. Is there any time lapse on the challenging termination of an appointment at the industrial court?
So NIC position is that employment cases are not caught by statute of limitations. So you can go to court at any time.
Okay. Sheyi is saying that I disagree with the last position. With the suspension without, yes, it said suspension without pay is illegal. I don't know if you had the category of what Bimbo was able to split suspension into 2 phases. And there are cases to support it. We may disagree, but when the matter comes to court issue, you find out that your opinion may not count when it becomes. But Bimbo shed more light so that Sheyi can understand the position of the law when it comes to.
There are 2 types of suspension. There is disciplinary suspension and there is investigative suspension. Disciplinary suspension is a suspension that is imposed because suspension is part of your sanction grid. And it is often imposed for minor misconducts. So you can have 2 days suspension without pay for insubordination, 3 days suspension without pay for persistent late coming to work. That is recognized by labor and employment law till tomorrow. And that is why punitive or disciplinary suspension is usually for a very short time. You hardly see suspension without pay for misconduct that is more than 2 weeks. In fact, usually for a few days. Suspension without pay as a sanction for minor misconduct. 1 day suspension without pay, 3 days suspension without pay. That is part and parcel of Nigerian labor and employment law. And it will be enforced by the court. And that is why it is hardly for a long period, usually for a short period. The one that has to be with pay is what is called investigative suspension, otherwise called administrative suspension in labor and employment law jurisprudence. Thank you. I'm not in doubt as to what I say. That is the law, sir.
All right, thank you so much, Mr. TJ. I think I'm very interested in this. I was actually the one who posted that question because it's been some sort of it's created some sort of conflicting opinion at some point. But it's okay, we're getting this clarity, but I also think it's important for those of us that are here to also do a bit of findings regarding same. Because prior to now, I knew that it's something that kind of contradicted industrial labor law. But I seem to be getting a different opinion from what facilitator is saying. So we'll need to fact check that. And
thank you very much.
Yeah.
Okay. Thank you so much, Mr. Ikem, for that. There's someone there, Ugoji Chima.
Okay, good evening, everyone. Though I posted a question on the message, but maybe it was not picked, so I decided to ask. Okay, so a situation where an HR is supposed to initiate termination, and the employee says, you know what, I want to resign with immediate effect. Now, I know the employee is meant to pay 1 month in lieu. At that stage, the employee says, oh, you know what, I'm not paying that 1 month in lieu. What will the HR do?
So, it's a contractual provision that where an employee resigns with immediate effect, he must make payment in lieu of notice. But like I said, employers hardly bother. So if he says he's not going to pay, you have a right of action. You can go to court and sue for the money, but if it was your time and energy, because it is a breach of contract to resign with immediate effect without making payment in lieu of notice. It's a debt which you can enforce in court of law if it pleases you.
Okay, there is a question here that says, how do you exit an employee before the completion? Okay, we've done that already. Yeah. We've already answered that question. Any other question? We are pressed for time. We should be rounding up in the next 2 minutes.